Can everyone hear me? Good evening. Looks like we're all gathered, so let's go ahead and get started. Thank you so much for joining us this evening for day 3 of Lake Oswego Reads. This has been already a wonderful month, and I think tonight will be no exception. So welcome, everyone. I would like to thank the Friends of the Lake Oswego Library for their generous support for this and every other program that we put on at the library. I'd like to point out that we have 2 board directors from the Friends Board joining us. Welcome. If you would like to support Lake Oswego Reads or the library, please consider joining the Friends of the Library for $25. The world is at your fingertips. You'll get the book and tickets first, and it's a great way to support us directly. If you've got one of these, please silence it so we show respect to our speakers. Thank you. I am thrilled to be able to introduce Peter Glazer and John Wentworth. Peter Glazer has served as a chair of the Governor's Advisory Committee on DUII under 4 governors and helped form the Clackamas County chapter of Mothers Against Drunk Driving in the 1980s. During his long and illustrious career, Peter prides himself, and I was very impressed, that he's never taken on defending a client for drunk driving. John Wentworth is our elected district attorney, a career prosecutor who began in Coos County in 1995, became a deputy district attorney in Clackamas County in 1999, and was elected Clackamas County District Attorney in 2020 and re-elected in 2024. Please join me in welcoming Peter Glazer and John Wentworth.
Age before beauty, so I get to go first. And as I was thinking about it, it was very easy for me to put my presentation together tonight because it's all memories. It's like war stories, and lawyers like to tell war stories. And John might actually have to have done some research and figured out what's really going on these days. My primary involvement with DUII was from about 1978 when I started as a deputy DA until 1999 when I decided to step down after serving under 4 governors as a volunteer on the Governor's Advisory Committee. But that's only to say that I have the easier role and John probably has the harder role tonight. I grew up with very little awareness, and I'm going to guess there's some people here tonight who have very little awareness of the problem of drunk driving. I know that at one point, our family, when I was probably a teenager still, probably living at home, a family friend or parents of my friends of my parents lost a child who was killed by a drunk driver. She was in a single car crash, and I knew that people did get involved in being victims of drunk drivers. But I thought it was pretty rare. I didn't hear about it very much, and I did not really think it was a serious problem. It was a few years later when I was 20, which would have been the fall of my junior year in college, that I became much more acutely aware of the problem of drunk driving. I was with 2 friends. They were in the back seat. I was driving. We had a small foreign car. It was my friend's father's car. We were driving through Chinatown in Portland, so we were on Northwest Everett at 3rd, if you know that intersection. And I don't think it's changed in this one respect. It's a blind intersection, and as we were going through on a green light, we were broadsided on the driver's side by a big American car driven by a drunk driver who ran his red light. And there, but for the grace of God, I would have been killed or seriously injured, and whoever was in the back on the left would have been seriously injured or killed. And I remember after that receiving trial notices, little pieces of paper, kind of a half sheet of paper from the Multnomah County DA's office telling me that there was a trial date coming up and I needed to be available as a witness. And after, I don't know, 2 or 3 or 5 of them, they stopped And I didn't really know what happened, but later, of course, I put two and two together and realized that that person, the drunk driver, had made some kind of a plea bargain, and hence there was never a trial. In the mid-1970s, the Oregon legislature decriminalized DUII. Someone thought that it would be a really good idea to make an offender's first DUII a violation, the first in 10 years, that's what that meant, the equivalent of a speeding ticket or a careless driving ticket. You could get fined, but you could not have a jail sentence. And the idea was that the courts wanted to push these cases through quickly, inexpensively. They wanted to avoid the possibility of a jail sentence, which had attached to it, of course, the right to a court-appointed lawyer and the right to a jury trial, and they would avoid the possibility of paying whatever was then $30 a day or $40 a day to incarcerate somebody at the Clackamas County Jail. Well, I remember when I heard about this decriminalization, and I was still in college, it would be the summer that I graduated from journalism school, I had a quick conversation with a state senator from the Eugene area. He might have been the proponent of it, I don't know for sure. But I told then Senator Ted Kulongowski that I didn't think that was such a great idea. That's Ted Kulongowski, who was later a two-term governor of Oregon, and a pretty decent governor and pretty good on the criminal justice system. But at that point, legislation to decriminalize DUII, maybe it was similar to the idea of decriminalizing, up to 1 ounce of marijuana, which they did somewhere around that same time, maybe the late 60s or the 70s. They thought that was a great idea. 3 years later, 1978, I graduated from law school, passed the bar, started as a deputy district attorney in Clackamas County, and we had 3 district court judges, we had 5 circuit judges, and in part I'm saying that so that John Wentworth knows that 47 years ago, we had like 2 less judges than you have today. So the population of the county's probably doubled or tripled, and there's 2 more judges than there were back then. Anyway, I quickly learned that about, I'd say 80 or 90% of the cases in district court were DUII cases. That was almost all we ever did. And the district judges, were just totally occupied with DUII cases. In general, by the way, we refer to DUII as drunk driving. That's a general term that I think people use to encompass various different technical crimes. In some states, it is known as DWI, driving while intoxicated, and in Oregon, the crime is driving under the influence of intoxicants, so DUII. In any event, when I became a deputy DA in 1978, there was a huge backlog of untried DUII cases. And why is that? Well, there had been a constitutional challenge. The criminal defense lawyers decided that this scheme of decriminalizing your first DUII and making it like a violation, well, that wasn't a good idea. And I'm not sure if that was because they didn't get to do the indigent defense of that person or for some other reasons. But in any event, they challenged it, the whole decriminalization scheme. Trials were postponed all over the state as everybody waited for the Supreme Court to rule, and after a long delay, while cases stacked up, the Oregon Supreme Court held that the defendant's first DUII entitled him to all the constitutional protections: right to jury trial, right to court-appointed lawyer, all the things they were trying to economize by avoiding. So you got all the constitutional protections, but you couldn't go to jail. So you got the court-appointed lawyer, the jury trial, and you could only be fined like you could for a speeding ticket or something like that. As a deputy DA, I saw the epidemic of drunk driving up close. Although I moved up quickly in the DA's office and was prosecuting felonies and murder cases most of my 3.5 years, I remained cognizant of the epidemic of drunk driving. And for a year or two, I was the vehicular homicide deputy. I carried a pager. Now, anybody remember what a pager was? You had it hooked to your belt, or you put it by on your bedstand next to your bed at night, so that when that little thing beeped, you could go running off to a crime scene where there had been a crash. Meanwhile, in 1980, a woman in California named Candy Lightner formed Mothers Against Drunk Drivers, MAD, after her 13-year-old daughter was killed by a drunk driver. And in 1981 or 82, in the Portland area, there were chapters being formed of Mothers Against Drunk Drivers. When I left the DA's office in 1982 and hung out a shingle in Lake Oswego, the biggest issue, now none of you will remember this, but some of you were around and paying attention back in 1982. The biggest issue all over the country was drunk driving. It had its 15 minutes of fame, if you want to use that expression. It was the cover story on Time Magazine, and Newsweek, and in Oregon, Governor Vicatia was running for a second term, and he appointed a task force to do something about drunk driving. So at the age of 30, I became the youngest member appointed to his task force, and in the next legislative session in 1983, we pushed the legislature to pass what were then called the toughest drunk driving laws in the country. So if you're a sports fan, you might recognize the phrase going from worst to first, meaning like you finished at the bottom of your league that year before, and this year you're up at the top of your league. It doesn't happen very often. Well, that's how I would describe Oregon's laws changing from decriminalization in 1975 to what were called the toughest drunk driving laws in the country in 1983. In 1983, in large part thanks to the efforts of Lake Oswego orthopedic surgeon Dr. John Tongue. Anybody know John Tongue? The presumption of being under the influence of alcohol was lowered to 0.08% blood alcohol. Previously, I don't think there was a presumed blood alcohol level, but there was a separate crime. In addition to driving under the influence, there was a separate crime of driving with a blood alcohol of 0.15 or higher. So that, in a sense, was a standard that people looked at as that's intoxicated or that's under the influence. In the 1983 legislation, a mandatory minimum jail sentence was established of 2 days in jail. And I don't know whether that still exists. John's nodding, so it does. But I'm going to say that that soon was weakened in practice when some judges decided that a defendant could start his sentence at 11:55 p.m., let's say on a Saturday night, and end it at 12:05 a.m. on a Sunday morning. And after serving that 10 minutes, that constituted 2 days, technically satisfying the minimum 2-day jail sentence. And John will have to tell us whether that still exists, but that did exist for a while. Anyway, maybe today. I served for 17 years under 4 governors as a volunteer at the Governor's Advisory Committee on DUII. I was its chair from 1986 to 1999, and I'm going to talk about those years. Early on, my drunk driving activities led to representation of people and victims in DUII crashes. And over the years, there were numerous DUII-related issues before the legislature. And I want to tell you about some of them. And John, again, can update us. I think I kind of know where things stand, but maybe not. There was one where we had to undo a bad court ruling. There's more than one bad court ruling, by the way. But this one was a court ruling that prevented police officers from being able to explain at trial, or a DA from being able to explain at trial, that a defendant charged with DUII had refused to take field sobriety tests. And that might seem like no big deal. But when a defendant was an experienced drinker, he often chose not to take field sobriety tests that he expected he would fail. And the law was that the DA and the police officer could not say anything about that, could not state that he refused, or could not state that the officer asked him to do field sobriety tests and he wouldn't do them. That left the jury with the impression, which many criminal defense lawyers exploited, that the police officer didn't even ask the poor defendant to do field sobriety tests and give him a chance to do those tests. Well, that wasn't very fair. So that was reversed by the legislature. Another improvement in DUI enforcement came when police began to undergo training to become drug recognition experts. DREs, they're called. And DUII is not only being under the influence of alcohol, it's being under the influence of a number of other controlled substances. Today, I believe many police agencies have specially trained drug recognition officers who can detect someone who's under the influence of drugs other than alcohol. And just as an aside, you may know this, and John could correct me, but I think it's probably still the case. It's often very hard to establish from a blood test, even though you know that somebody has remnants or some of the substance of, let's say, marijuana in their system. It's hard to know that they were under the influence of that at a particular time. Alcohol, it's now pretty well accepted that there's a dissipation rate. You take a blood alcohol sample and you go back in time and it dissipates at a certain rate. It generally builds up at a certain rate. And you can kind of analyze what somebody's blood alcohol level was at the time that he was driving, let's say, as opposed to, the time he's at the jail and they run a breath test or somebody takes a blood sample that's analyzed later. Anyway, drug recognition experts, I think, have improved greatly, and obviously there's been an expansion of the use of other kinds of controlled substances that cause people to be impaired drivers. Technology advanced during this time. Ignition interlock systems were developed, and these, as many of you probably are aware, are aftermarket devices that would stop someone who's had too much to drink from being able to start the ignition of his vehicle. And one of my favorite laws passed at the tail end of my 17 years as on the Governor's Advisory Committee, felony DUII. And I had argued for years that if someone had multiple DUIIs, we often had cases with somebody with 2 or 3 or 4 DUIIs at the same time and a recent history of other DUIIs, and the punishment that was available was the same as it was for a first offense or a second offense. You could be punished for up to a year in jail, which nobody hardly ever got, or a $1,000 fine. So felony DUII would give a judge the opportunity to sentence someone more severely, and it's supposed to be a deterrent. I don't care whether somebody has to be punished after they did it. I'd much rather they didn't do it and they were deterred by the idea that they might actually go to state incarceration for a felony DUII. So felony DUI passed in 1999, and at the end of that year, I stepped down from the Governor's Advisory Committee. Over many years, societal attitudes about drinking and driving have changed considerably. In the 1970s, it was socially acceptable to drink and drive. A DUII defendant was often viewed by jurors as, that could have well been me. Well, jurors acquitted many guilty defendants because they identified with the defendant. Starting in the 1980s, I'm going to say, just like smoking cigarettes became socially unacceptable to many, so did drinking too much and driving. And in the 1980s and 90s came the idea of designated drivers. That didn't exist in the early 1980s. A group of friends could go out partying or to a sporting event, and one of those would essentially agree or pledge not to drink and to be the sober driver that would get everybody home safely. I have a few other observations. We do not have roadblocks or sobriety checkpoints in Oregon. Why not? Because 30-some years ago, the Oregon Supreme Court decided those were unconstitutional under the Oregon Constitution. So I know this is in the weeds a little bit, but I'm going to say under the U.S. Constitution, they're constitutional. They exist in many states. I've seen them in Hawaii. I don't know how many other states have something like that. And there's certainly a deterrent to somebody driving under the influence, at least on that road that night. But roughly 35 years ago, it was decided that they were unconstitutional under the Oregon Constitution. And a state like Oregon has the right, and in many cases has exercised the right, to be, quote unquote, more protective of someone's rights than the federal Constitution. It can't be less protective, but it can be more protective. And that was the basis of the Oregon Supreme Court's decision. For there to be public safety, there have to be ways to deter unsafe conduct. And I have concluded that there are basically three ways, and I'm going to tell you what they are in my opinion. There are three ways that society can enforce behavior that's important to public safety, and these are, by the way, in addition to religious upbringing, parental education, and just generally how people are brought up. The obvious first one is criminal laws. Criminal laws deter many people from doing whatever it is that is prohibited. The second works only in certain kinds of situations, and that is regulation by a governmental agency. It obviously works for disciplining lawyers or doctors to have a regulatory agency that, or like the Board of Medical Examiners, that sets standards for doctors, and if they don't comply, they're disciplined. In theory, it should have worked for the Oregon Liquor Control Commission. That's what it used to be called before they added cannabis to their name. It should have been workable for the Oregon Liquor Control Commission to regulate the service of alcohol by taverns, bars, and restaurants where people were routinely overserved. But in my experience, it never worked effectively. And if you ask me later, I'll tell you why. The third way of trying to enforce public safety is through the civil justice system. And that's lawsuits that hold wrongdoers accountable and should have the effect of deterring others. We're seeing more of that in recent decades, and I'll give you a couple examples that I know you will think of. There have been numerous lawsuits against child protective agencies that did not do their job right, against organizations like the Boy Scouts and churches and tobacco companies. And to some degree, those lawsuits and the results of those lawsuits have deterred further conduct. Related to DUII is the plain fact that too many drunk drivers get served at a bar, tavern, or restaurant where they're served while they're visibly intoxicated. They leave, they get in a vehicle, and they cause a crash that injures or kills innocent people. I mean, this is like you're on the road and somebody comes across, the opposite way, comes across the line suddenly and crashes into the front of your car. It happens too often. Oregon has civil laws governing the liability of a bar, tavern, or restaurant or social host for serving visibly intoxicated persons, and in my opinion, that's a good thing for public safety. For decades, that didn't work very well for bars and taverns and restaurants because irresponsible owners of a bar or a tavern would simply go without insurance. They just decided, well, we're just going to structure our business so we don't really own anything, and then we'll just do what we want to do, and if we get sued, we don't have insurance, and we don't own the building, and we don't really own any assets. So one of our accomplishments over the years was to get the legislature to mandate that all bars, taverns, and restaurants have insurance, just like Oregon requires all lawyers to carry insurance and requires all of our cars to be insured. Traffic safety is enhanced when there are criminal laws to help protect you, regulatory agencies to oversee licensees and protect you, and civil liability that is a deterrent and should help protect you. That ends my recollections and my remarks, and now you get the real story from Clackamas County DA John Wentworth.
Thank you, Peter. I have a lapel mic. Can folks hear me well enough? It was on. Let's see if it says it is. I'll try to speak up enough to where folks can hear. You can't hear? Oh, okay, great. That is a very complete summary of the DUII law. That when I started as a young prosecutor, I basically picked up where Peter left off. it's amazing to me in hindsight how history repeats itself. We're going through this same time right now of decriminalization, and what do we do about that? And is that a good thing or a bad thing? And does it help people or hurt people? This was, I'm sure, the conversation that was going on with DUII when the decision was made to make it a violation. We can save money. We're hearing that in the legislature this current legislative session. We can take misdemeanors and make them violations, and that'll save the taxpayers lots of money on indigent defense because there's an indigent defense crisis. We're just repeating the same stuff that we heard in the 80s. And there are consequences to that. And we've learned about some of those consequences through like ballot measure 110, for example, right? And I know this is a little bit of a tangent, but I just want to tell you how it's coming full circle. When ballot measure 110 went into effect, the idea was we're gonna take drug possession out of the criminal justice system and put it exclusively in public health. And that makes a lot of sense. I mean, you know, a lot of people I know voted for that because it sounds wonderful. We want people to get treatment if they have addiction issues. That's fantastic. And so the idea was if they catch John Wentworth with a small user amount of drugs, hard drugs, cocaine, heroin, things like that, I would get a ticket. And the ticket was for $100. They actually had to add an extra violation level to Class E violation so that, and I'm not exaggerating, if you were to drive 1 mile an hour over the speed limit, the ticket would be more expensive than if you were also handling a bundle of methamphetamine. That's where we were in Oregon. But you could get out of the ticket, and all you had to do was reach out for help. You had to make a phone call, and if you made the phone call, your ticket goes away. Now, in the 3 years that ballot measure 110 was in effect, 8,000 tickets were given across the state of Oregon. All right? How many people do you guess made the phone call for help? 5? Do I hear 10? 8,000 tickets. You're actually not far off. 50 people made the phone call. 50. How many of those 50 people got treatment? Not one. Right? The way people were getting treatment in Oregon, and we stand as the worst state in the nation for treatment options. We have very few treatment options. If you need help with substance abuse, it's hard to find where to go in Oregon. We ranked last, right? And the way people were getting treatment was through the criminal justice system. So we saw the effects on our streets. We saw the effects in our communities. We're one of the worst states in the country for fentanyl overdose deaths. We're still feeling the effects of that, right? So now we've come back to where, okay, that didn't work. We need to recriminalize again and get the criminal justice system involved. What's interesting when I listen to Peter's recitation of the history of DUII, the battle was in your time, the battle was in what do we do in the court system with folks, right? And the idea was we're gonna make it a violation. The battle now is not in the court system. If you sit and listen to what happens with a DUII, and let's take if I don't know how you feel about diversion, but the first time you get a DUII, you get to go into diversion. You divert it. There's a treatment program for you. There are license suspension issues that you have to grapple with. You can't drive your car for 90 days. It's a huge pain in the butt, right? It's really, you have to have an interlock device on your car. It's a huge burden for a diversion. I don't want to it sounds nice to get a diversion, but it's really not easy to get through, okay? If you were to sit and listen in court, you think, well, okay, that's a lot. You get a big fine, you have to do all these things. That's a good thing. The battle now is not in the courtroom for protection of the community. It's with our Court of Appeals. The Court of Appeals has almost made it impossible for a police officer to actually conduct a DUII investigation. You may be familiar with one of the standard field sobriety tests as being, can you say the alphabet? Don't sing it, just say it from A to Z, right? That's now considered testimonial, and a person has a right to remain silent and they don't have to do that FST, right? So then you say, well, can we do physical field sobriety tests, right? Which might include what we call the walk and turn. So you have to walk a number of paces, put your heel to toe, right? Maintain your balance for that length, and not put your arms up, and not do this, not do a Walinda. Anybody remember the flying Walindas? Am I alone? I can't be alone. So you can't do that, right? The Court of Appeals has made it very, very difficult for the police officer on the scene to gather the evidence that's needed for a jury or a judge to determine whether someone was under the influence. So that's the new battle. That's where we're at right now. There are things that have improved in terms of making DUII a felony. If you have 3 DUIs within 10 years, it's a felony. It's still a probation, so it sounds really onerous, but it's really no more impactful for that 3rd or 4th DUII than just getting a misdemeanor DUII, except you have a felony on your record. But now we have expungement laws that allow those to get erased over time. So we still have work to do. So what does that mean in Oregon? I have some sobering, I'm using that pun intentionally, statistics. Every 39 minutes in the United States, someone dies from a drunk driver. Every 39 minutes. That's over 13,000 people a year who don't have to die, right? The public awareness campaign is out there. Everyone knows not to drink and drive. The hard part, and Peter touched on it early in his presentation, is that people do. And they're not necessarily bad people who do that. I'm not going to demonize anybody, right? Because I'll bet, you don't have to raise your hands, there have been people in this room who've had 1 or 2 drinks, maybe 3 drinks, and you think, I can make it home. It's going to be fine, right? And it's not drinking and driving alone. You do have to have a level of impairment for a police officer to be able to prove a case beyond a reasonable doubt of DUII. But we all know it's not uncommon that the 1 drink takes a 2nd drink, takes a 3rd drink, and you become drunk, right? That's the challenge. That's the real challenge for us. How do we get people to, we have Ubers and Lyfts and taxis and Friends and buses and TriMet, the Max. There's so many other alternatives, and yet people will drive their car home. The other thing that I can tell you anecdotally, I can't tell you statistically, although from this conversation I'd like to do this, the person who dies in a crash is not the drunk driver. It's almost always the driver of another car or the drunk driver's passenger. I don't know why. There's something to it. It's not just anecdotal, it's a fact. That's what happens. So what about Oregon? I'm sad to say, despite the efforts that Peter engaged in, that his peers engaged in, Oregon now ranks as one of the bottom 10 states for traffic deaths due to driving under the influence. We don't just have drinking and driving that's an issue. We have substance abuse issues as well. People who drive while on heroin or cocaine or a combination of things or fentanyl or prescription drugs. There are all these things that contribute. It's not just DUII. My bit of history was that I was in the first class of prosecutors trained to prosecute using drug recognition experts. Police officers who are trained to identify, based on physical characteristics of a person, whether they are under the influence of controlled substances, not just alcohol. Now to tell you, I've shared this, the way they used to do it when I first started as a prosecutor was that the police officers went down to Burnside to find people who were under the influence, right? There was a time in Portland where there was a place you had to go to find someone under the influence of drugs. And unfortunately, it's ubiquitous now. You don't have to just go to Burnside. You can go almost anywhere and find people who are under the influence. we unfortunately see it on our streets. We see it in Clackamas County, I'm sad to say. So how are we doing in Clackamas County? Depends on what you think about it. The DA's office, my office, reviewed 1,269 misdemeanor DUIs last year. 1,269. That's a lot. Okay, so that's what, 10 a month? No, 100 a month, right? Now, the bad news, we're not the only ones who review DUIs. There are 5 municipal courts in Clackamas County, or Lake Oswego has one of them, right? So I don't know what the Clackamas County in total number is. I would say it's probably double that 1,200 number, which is, it's stunning to me. We charged 33 felony DUIs. Remember, the way you get a felony DUI, you have to have 3 DUIs within 10 years, right? Someone who just doesn't get the message. And again, that is a diversion. The 3 DUIs are actually 4 DUIs. Diversion, first conviction, which is your second conviction, third and fourth, right? It takes a lot to get a felony. There were 33 last year. And then we charged 4 vehicular homicides where there was substance abuse. The homicides resulted from substance abuse. I'm curious, how many of you read the book? You all read the book. Okay. So I want to talk about the homicide aspect of it, okay? Because I know one of the questions was, how would this case have been handled in Oregon or handled in Clackamas County, however granular you want to get. The sentence that Violet, is that her name, that she received was 28 months, and she got time off for good behavior, right? That may or may not happen in Oregon. So this is the audience participation part. I printed out copies of Oregon sentencing guidelines, and we're going to do a little workshop here. It's super easy. I'm going to show you how easy it is. So this fancy, and you'll see it as it comes back, this fancy, colorful chart, this is actually 2-sided. I just printed out the one side because we're going to walk through this a little bit. Every felony that a person can be convicted of in Oregon is on this page right here. That's why the print is so small. All right? Now, there was a time in Oregon, and Peter might remember this, I don't know, when we didn't have the sentencing guidelines. Ted Kulangowski, to give him more credit, was really instrumental in doing this. So the sentencing guidelines was a way that the legislature decided we need a way to standardize sentences across Oregon. It's not fair that someone in Jackson County gets a different sentence, a very different sentence, than they get in Clackamas County just because they live in a different county. We need to standardize what happens to folks, right? So this was the first attempt to do that. So what you have here, I'll start at the top. In yellow, these are in months. These are months in prison a person can spend for the commission of a crime. And then there's a bold line, and then there's green, blue, and purple boxes. Those represent days in jail. Okay? So yes, you can go to jail for committing a felony. And I just got a picture of myself violating the copyright law at the bottom. Darn it! Okay, so the way, social media. Okay, so the way you do this is a crime on this side there are numbers. Those numbers represent a crime seriousness. So the less significant a crime is, the lower the number. So possession of a controlled substance used to be a 1. Okay, murder is 11, by example, and then the top part of the matrix, you've got letters I to A. I is someone who's never been in trouble before, and A is someone who has 3 or more person felonies on their record. Jack the Ripper, right? Really, really bad people. And the way you determine what a sentence will be is you take a crime. I'm just going to look here. Bias crime. Bias crime is a 6. If you look on over here, and so 6 is the guideline. And if you've never been convicted of a bias crime before, you're looking at 90 days in jail. That 90 is actually 30. Because in order for a judge to impose 90 days, they have to make a finding that there's adequate jail space in their jail, and our jails are full. So when I was in Coos County, we had the largest jail per capita, and our judge made the finding that all the time there's adequate jail space in the Coos County jail, so we're going to impose what you see there. Otherwise, it's always cut in a third. So that 90 days is actually 30 days. Okay? So let's bring us to the vehicular homicides. Manslaughter is typically what we would charge in a DUII homicide case. There are 2 ways. Well, actually, there are multiple ways, but manslaughter in the 2nd degree is recklessly causing the death of another with a dangerous weapon. And I think we can all agree, it's like just, we don't even have to argue it anymore, that an automobile being driven by a drunk driver is a dangerous weapon, right? So that's manslaughter in the 2nd degree. So if you go to our matrix here and you say, okay, most people don't have that kind of record, they've never gotten a manslaughter before. What would that be? I want you to look at this red box in the middle, okay? And go over to the far side where it lists numbers. So manslaughter in the 2nd degree is a 9 or an 8, okay? It's a 9 if the case involves a motor vehicle and alcohol or some controlled substance. So that's a 9. So you go to our grid, someone who's never been in trouble, they would be looking at 34 to 36 months in prison under the guideline sentence. 34 to 36 months. Okay? Now, the real bad news is that 36 months in prison with good time, earned time, all the programming that a person can get is actually 20 months in prison. Right? So they're shaving off more than a year off their sentence. So in 1994, Oregon voters were given the option of they voted. There was a huge issue, as you'll remember, in the 80s and early 90s with violent crime just being rampant through the United States. And every state in the union created some version of get tough on crime legislation, sentencing. Oregon was one of the last. But our version was ballot measure 11. Okay? Ballot measure 11 set mandatory minimum sentences. People said it's not right that a person is sentenced to 36 months, but they actually do 20. Right? That's not truth in sentencing. And it's kind of light for killing someone, for taking another life. Doing 20 months in prison really isn't that long. And so they instituted ballot measure 11. They voted for ballot measure 11, and that's where we get these numbers over here, which say a manslaughter in the 2nd degree is 75 months. So it's a little over 6 years now for taking someone's life, having consumed a controlled substance, or drinking and driving and killing someone. Now there's another homicide I want to talk about, and that's manslaughter in the 1st degree. And that occurs when let me find my note here. When a person acts recklessly, we all agree that drinking and driving is reckless, right? You are consciously disregarding the substantial risk that someone's going to get hurt when you drink and drive. That's what recklessness is. But manifesting extreme indifference means it's extra bad. It's extra reckless. There's more to it, right? So it's one thing to get into your car and drink and drive and hurt someone. It's another thing if I have to tell Peter, Peter, do not drive. You should not be driving. Give me your keys. I'm not giving you my keys. I'm going home, right? You're going to kill someone, Peter. This is the kind of evidence we offer at trial. I'm not going to kill anybody. Get away from me. That's manifesting extreme indifference. Because I'm telling Peter, you're going to hurt somebody. You're not safe. And Peter's disregarding what I say. That's manifesting extreme indifference. Another way to manifest extreme indifference is to hit and run. If I crash into somebody and I try to drive away, and I know they might be hurt, I'm manifesting extreme indifference to the value of human life. We have people, we just prosecuted, we just got a man 1 conviction for someone who was high on mushrooms. He manifested extreme indifference because he had previously gotten high on mushrooms, crashed his car, and he almost died. And then healed, used mushrooms, got into his car, had a passenger, drove, killed his passenger, and another head-on. There was another person who was killed as well. And when asked, when told, hey, both the people involved in this, besides you, were killed, he eventually laughed about it. He blamed his passenger for getting in the car with him. We had that jail phone call that was in a phone call that he made 5 days later. That's manifesting extreme indifference. So you can manifest extreme indifference immediately before or during or after the crash. Okay? So when you look on your chart at what the sentence would be for that, that's 120 months. That's 10 years in prison. There's no early release. You don't get out early. You can't go through a special program and get treatment. It's day for day, 10 years, right? It used to be, if we look on our chart, it was a 10, so that was 60 months. Worst case scenario, 60 months. And you get good time on that, and your sentence would actually be, what do I do with my chart? 60 months would be 35.4 months for taking a life. So you can see why the Oregon voters went that much time for recklessly endangering someone and manifesting extreme indifference. 3 years is just not enough. It's not even a full 3 years, right? So our sentencing has gotten harsher. The challenge is we still are making it very, very difficult for the officer on the road to actually do what they need to do to hold offenders accountable in the moment. It's almost impossible. And I don't like to deliver bad news, but I want to be realistic. We have a lot of success anyway. Every time new laws come out, we train officers on what to do, how to do it better, how to ensure they're in compliance with the law, but it's not easy. They're out there, they're learning, they're trying to do the best they can. The thing I'll also add is, I want to go back to the good people. These are cases I hate. I don't like, most of the time when we get young people who should know better, but they still drink and drive, you know, they're not always 21. The Reynolds defense firm, have you heard their ads on the radio? There's a defense firm, and they say, we represent good people accused of DUII. And jurors will be on the jury panel and think, that could have been me. That could have been me doing that. I have a few, right? And that relationship to someone who doesn't look like a terrible person, they don't look like a murderer, like someone who would commit homicide. They don't look that way. They look like the rest of us. That's very difficult to overcome, right? And oftentimes in the rest of their life, they might be very, very good people, but they've also taken a life, and there should be a consequence to that. Part of what we do isn't just rehabilitate, it's deter. Our job is we want people to think, if I do that, not only will something tragic happen to someone else, but something tragic will happen to me. Something tragic will happen to my family. That deterrence oftentimes will keep people from making bad decisions. They will get a taxi. They will get an Uber, right? We want that to happen. So that's a lot. I got the heavy of talking about death in prison. But what I want to do is give you an opportunity to ask Peter and I any questions you might have about what's in front of you or about DUII. Yeah.
How helpful has the body cams been in prosecuting, either good or bad? Is it a wash, as far as the officers with body cams? Have they proven beneficial to incarcerating?
I love body cams. I love body cams. I love them for so many different reasons, and not just DUII. Part of my passion is also in the world of domestic violence, right? And oftentimes, before we use body cams, we would have folks say, I never said that to the officer. I never said that, right? Well, now we have it on tape. Or being even more charitable to the officer, they might write in the report, the victim was upset. Well, what does that mean? Does upset mean angry? Does upset mean they were crying? Does it mean, I don't know what upset, but I can see what upset means. And so when we were able to get dash cams in police cars so that we can see what the officer saw, and especially with the body cam, it's even better in many instances. Now it takes out a lot of the guesswork, right? The difference is that a police officer is trained to notice nuances that you don't necessarily see. Like when I did this, we all know that's drunk, right? But you don't have to be drunk. If you're under the influence, that's a lesser standard. That's the 0.08, not the 0.15 or 0.2 that this would be. If my ability is impaired in any way, I shouldn't be driving the car, right? That's the standard. And that's what police officers are better trained to identify in the moment.
Is data available on how many of these people with DUIs are alcoholics? And if so, is there any program available to help that?
Thank you. The question was, is there any data available on how many of the people that we get with DUI are alcoholics? And the answer is, I don't know. Part of it, I don't think so. And the reason is, when someone goes into DUII treatment, we treat them as alcoholics, right? Because if you ask an alcoholic, how much do you have to drink? I have a couple drinks a day. I have a couple beers. They lie about how much they really drink, right? So that you have to treat them just like everyone like they're an alcoholic, whether it's their first time or it's their 50th time. We don't know, and so I don't know if there's data on that, but I can just tell you how we treat every single person.
Would they have to agree to the treatment, or is that part of the sentencing?
If they want to go into diversion, they have to agree to the treatment, and if they get sentenced, they have to do the treatment, or else they go to jail. So there's a double incentive. Yeah. Yep. So the question. So the question is, what's the percentage breakdown between people who are just driving under the influence of alcohol versus drugs versus alcohol plus drugs? We see both of those, all three of those, right? About 40% of the cases that we see are polysubstance abuse cases. By that I mean more than one drugs on board. It could be alcohol and cocaine, or alcohol and fentanyl, or alcohol and marijuana, or any combination of those. The other 60% appear to be exclusively alcohol or exclusively some other drug. But about 40% are polysubstance abuse.
Mothers Against Drunk Driving, what exactly do they do? What does that involve?
You know, I'm not sure what Mothers Against Drunk Driving does in Oregon now. I don't know how many chapters are active. There's still a national Mothers Against Drunk Driving that is very strong. What they did in the 80s was they started doing court monitoring. Mothers, volunteers would go sit in the back of a courtroom, and a judge would basically send their bailiff up or their judicial assistant up and say, hey, who are you? What are you doing here? Well, and they'd say, I'm a court monitor from MAD. The judges actually began to kind of pay attention to this was a more serious problem than they thought it was before, or that they acted like it was before. Mothers Against Drunk Driving obviously had an effect, either literally lobbying or citizen lobbying to get laws that were strengthened. Mothers Against Drunk Driving was very active in the 1983. I hate to go back that far because that's 42 years. That's a really long time ago. But very active in helping to get the legislature to pass some laws that sometimes legislators did not really want to pass. You know, I'm sure it's not a secret, and if you think about it, one of the problems I invited you to ask me a question about OLCC, but I'll just tell you similarly, really one of the problems is that in every legislative district, there is a tavern or a bar that legislator may go to frequently and may be friends with the owner of. And when it comes to laying down the law and trying to say we're going to enforce liquor laws in Oregon, there's always an important legislator that can say, hey, you need, or owner of a establishment in that legislator's district, and say, hey, you need to go light on us, make sure that OLCC doesn't have funding or OLCC doesn't clamp down. I called OLCC a toothless tiger or something like that at one time. I don't think it's any better now, but I really don't know for sure. Or I actually called it a scaredy cat organization, because they basically couldn't do a single thing. They were worried about an important legislator. They didn't know which one coming down and taking away their funding or doing something like that. During the time that I was active, and I don't know that it's still true, but I'm going to guess that it is, OLCC was comprised, let's say, of people who had a law enforcement background and people who did not have the law enforcement mentality. And OLCC in the 90s, I think, basically decided, or it was decided for them, that when a liquor licensee was proven to overserve somebody, they served somebody who was visibly intoxicated, that driver went out and maybe killed somebody. There's numerous cases on Highway 99, between Sherwood and Newburgh, divided highway. Somebody'd get out of one of those taverns, go the wrong way down the road and collide into somebody that was going the right way. OLCC basically was told, you're going to become an educational organization. You're not going to be a law enforcement organization. So they were supposed to go out and tell the owner of that tavern or that bar, well, it really isn't a very good idea for you to be over-serving people like you did in this case, where this guy went out and then killed somebody head-on going down the highway, half a mile from your establishment. But it turned into an educational organization. And that was not because OLCC wanted to do that necessarily. It's because the legislature chose to basically tell them that's what you have to do. I know we're out of time. Nancy's over here ready to give us the hook.
The hook.
And I'm used to getting the hook at my Rotary Club anyway.
You mentioned in the 70s when you were caught the first time, nothing really happened. So what happened if you kill somebody the first time? Because you killed, what happened then?
What was the sentence in the 70s?
No, you said that in the beginning that you were caught for drunk driving, nothing really happened, so you just got a little citation. But what happened if you killed somebody the first time that they caught you?
Yeah, I don't know for sure. I'll tell you what I know about the state of criminal law and deterrence in Oregon. 1978 to 82, those were the years that I was a deputy DA. We had not built prisons in Oregon for 30 or 35 years at that point, since the 50s. The population of Oregon had about doubled, and the population of my age group, which is now obviously a senior citizen, but we were the baby boomers, and at that point we were the high crime demographic, males between the ages of 18 and about 30. And in Oregon, there was an epidemic of crime. And John has no idea because he was way too young. But sentencing guidelines were a very good thing. First of all, they reined in judges in Multnomah County who were way, way more lenient than judges elsewhere in the state. But secondly, it used to be, and I prosecuted felony cases, Class A felony cases, got a conviction. The judge would hammer down that gavel and say, I'm sentencing you to 20 years in the state penitentiary. Does anybody have a guess as to how long that person served in 1980? 6 months. They were out on a pass in 6 months because we had so much prison overcrowding, so little capacity for the expanding population and the expanding demographic of males of my generation, the baby boomer generation. And somebody would get out on a pass in 6 months after shooting somebody, trying to kill them. They didn't die, so it was attempted murder, Class A felony, 6 months. It was really bad. And sentencing guidelines were a refreshing change. And toward the back of our room is Steve Dole, who had a lot to do with Measure 11. Thank you, Steve. If you ever hear criticism of Measure 11, look for the other side of the argument, too. I mean, there's people that say, oh, it's just not fair. But John pointed out the situation with vehicular homicide. You want somebody to kill somebody and go to prison for less than 3 years? Maybe, but I don't think so.
Does each state have their own laws?
Yeah, each state has its own laws. Yeah, that's fundamental. I mean, we live in a country that has 50 states with 50 different laws on almost every topic. And I don't mean just criminal laws. I have done divorce work, and there's 50 different laws of, you know, how you handle issues in a divorce case. There's 50 different laws of everything in the 50 states. Some might be similar, but there's a variation. No two states are the same. Nancy, are we getting the hook?
Thank you so much for taking the time to come and share your wisdom and experience.